Hello, my name is Timo Becker. I'm with Becker International Law here in Miami, Florida. I'm a German-American attorney and I work with international entrepreneurs and investors who want to start a business in the US. Many of you may have heard C-Corporation, S-Corporation, pass-through entity. But what does it all mean? It is important that you understand that these are tax terms. C-Corporation or S-Corporation are named after Subchapter C or Subchapter S of the Internal Revenue Code. So in order to understand entity taxation, you have to understand the two concepts of entity taxation. There is the corporate model, where the corporation itself is a legal entity for tax purposes, and there is the partnership model, where not the partnership itself is subject to tax, but the members or the partners of that partnership are subject to tax. So what is a C-Corp? A C-Corp is a legal entity for tax purposes. A C-Corp itself is subject to corporate income tax. We have two levels of taxation for corporations. Either one is on the federal level, the other is on the state level. There are some states that do not have a corporate income tax, such as Delaware, Nevada, but most of them do. In a C-Corp, there's two tiers of taxation. One on the entity level, and then if a distribution is made to one of the shareholders, then the shareholder will also be taxed. The dividend that he will receive will be taxed. Right now, the tax rate for qualified dividends is 15%. Sometimes 20%, depends on your tax bracket. The advantage of the C-Corp is that it can be used as a tax shelter. So as long as there's no distribution, there will be no tax on the shareholder level. If you want to determine your tax burden in a C-Corporation, you have to always add the tax on the entity level and the tax on the shareholder level. The big advantage of the C-Corporation is that it shields the shareholder from taxation. So for example, we use corporations or C-Corporations oftentimes as blocker corporations in order to protect, let's say, a parent company in a different country from taxation in the US if it has a subsidiary corporation in the US. What are pass-through entities? Classical pass-through entities are the general partnership and the limited partnership. By default, the LLC is also a pass-through entity. The main difference between a pass-through entity and a C-Corp is that there is no taxation at the entity level. Only the partners will be taxed at their graduated tax rates. The income will be allocated to the partners at the entity level. And then the partners will declare their share in their personal income tax returns. The advantage of a pass-through entity is that there is no two-tier taxation as compared to the C-Corporation. Also, the partners will be treated as if they hold company property in their own name for tax purposes, which means that the reduced tax rate for long-term capital gains is applicable if property is sold. The LLC, by default, is also a pass-through entity, but as a hybrid entity, it can opt to be taxed as a C-Corp, which makes it the most flexible entity for tax purposes. Pass-through entities are very popular with small business owners and real estate investors. So what is an S-Corporation? An S-Corporation is basically a corporation that opted to be taxed as a pass-through entity. There's certain advantages of an S-Corporation that have to do with self-employment tax, but I don't want to become too specific here. You can only form an S-Corporation if you fulfill certain requirements. The S-Corp has to be domiciled in the US. There has to be an allowable shareholder. For example, other corporations or partnerships cannot be a shareholder of an S-Corp. And also, which is very important, Non-resident aliens can also not be shareholders of an S corporation. Also, the corporation, that's why sometimes people call them small corporations, cannot have more than 100 shareholders.